I'm Drew Stevenson. This is a lecture for my Statutory Interpretation and Regulation class about why do we have so many statutes? Why are there so many statutes for courts to interpret? What happened to the good old common law days when we could just follow precedent and add to it incrementally? How did we get here? That's what this video is supposed to answer for you. First, remember that after the Civil War, we emerged from the Civil War with an ascendant federal government that took on aspects of lawmaking and governance that had previously been the domain of the states. And some of this was because the federal government had a chip on their shoulder, maybe that they had won the war. And part of it was that this is what the states actually kind of wanted. So there was pressure from a lot of different directions to have more laws to deal with post-Reconstruction America. We also had waves of immigration during this period and so forth. And so Congress just legislated more. Also, probably with the sort of ascendancy of the federal government and the centralization of power in the United States, there was something to be said about economies of scale for federal governance. And so Congress we have a proliferation of statutes in the late 1800s and early 1900s. Secondly, in the late 1800s and early 1900s, new states joined, and also the railroads and canals and channels and highways, the early highways, connected the country in new ways. So a lot more activity went on across state lines. And so there were both good and bad. So there was more pressure for laws governing interstate commerce and interstate crime and transportation, just the transport of goods and people back and forth across state lines regularly. It's hard to imagine a world before we had railroads and paved two-lane roads or four-lane highways and parkways and automobiles and things like that. But it was very easy to live your whole life within one state or town and basically never get out, or to venture out maybe once. So we didn't have as much interstate commerce. We didn't have as many like interstate smuggling cartels and things like that. And by the same token, not only was there a lot more commerce activity, interstate commerce going on, but this made people start thinking about that sort of forgotten clause in the Constitution, the Commerce Clause. The Congress had the power to regulate things affecting interstate commerce, because once we have railroads and highways and canals and things like that, and automobiles and airplanes, it starts to feel like everything affects it. All commerce is interstate commerce. And so Congress started thinking that they could and should regulate more. A third factor here is the transition from the abolitionist movement for slavery to the addiction problems in our society. And so, and we don't talk about this a lot in statutory interpretation, but it's actually a big deal, and it's a big part of the explanation about where we got some of our criminal procedure rules, like the entrapment defense and things like that. After the abolition of slavery, after the Civil War, a lot of those progressive abolitionists, the same people who had fought for years to abolish slavery, turned their attention to other social reforms and to social problems like addiction, which they analogized to slavery. And to be honest, a lot of times they took the metaphor a little too far, right? But the idea was there were widespread substance abuse problems in the United States. I'm recording this video at the end of 2020. We're in the middle of the COVID crisis, but before that, we had about 3 years of an oxy crisis with addictions and record numbers of overdoses from oxycodone and the other oxy drugs being used recreationally, and so that a lot of people perceive that this is a widespread problem. And social reformers in the late 1800s were very concerned about the devastating economic effects that they saw alcohol and then the newly arriving narcotics that were coming into the country and things like that were having on poor populations that were concentrated in urban areas, and also on rural areas, the sort of the saloon system that kept a lot of families in poverty and created a lot of social problems and interpersonal violence and things like that. So there was a big movement to regulate alcohol and narcotics and the sex trade and things like that that people saw as types of slavery, really. And that, at least that's what they called it. I understand that treating human beings as your property that you can buy and sell is in a whole other league, but they saw this addiction as something that's very hard to escape, and they wanted regulation. And this is where the pressure mounted for the federal government to get involved, and then to have a federal police force to enforce it, and so forth. And people underestimate how much the transition from the abolition movement to temperance and banning addictions and substance abuse really gave rise to our modern age of statutes. Okay, fourth is the codification movement. And after this really started to take steam and pick up steam on the state level only after the Civil War, and really only with the new states joining the Union mostly. But then after World War I, we finally got a US code. Our federal statutes were codified for the first time between World War I and World War II, with topical arrangement and numbered titles and sections and lettered subsections and so forth. And before this, for our whole history before that, public acts, and then after the Civil War, they were published in a series called the Statutes at Large, were published chronologically, only chronologically, which made it very difficult to determine if there was a relevant statute. I want you to imagine that you have a set of the statute books in your law library at your law firm, and they are in order, the books are and statutes are arranged in order of enactment by date. And you need to know, is there a statute about arbitration clauses or highways or retirement benefits or something, workers' compensation? And how would you find that? Maybe you have a good index, or somebody could say, oh, the law was passed back in 1905. Look up the 1905 books and you'll find it. But what they didn't tell you was that in 1910, the statute was amended in a rider in another statute. This made it almost impossible for courts and lawyers a lot of times to even find the statutory law that might bear on a case. This, by the way, was part of the job of early law professors, was to produce, this is why treatises and horn books and digests mattered so much, is that there were academics who would keep up with new laws as they got enacted, and then kind of put out these topical books. Well, today, you can pull off a title off the shelf of the USC, and it's all going to be about the same thing. And then it's going to be logically arranged and numbered and lettered and have this sort of hierarchical layout and so forth. It's hard to imagine, if you didn't live in the world before we had this, how revolutionary the codification was for the practice of law and the and for adjudication of cases and application of statutes. You could have the statute at your fingertips, even without a computer searchable database. So the codification, these enumerated and hierarchical statutes that were arranged topically, made it a lot easier to include, for the Congress to include cross references to other statutes or even sections of the same statute. So if you wanted to just incorporate another statute by reference, you could. And that's really saved a lot of time because you could just look it up and refer to it by number. You didn't have to refer to it by the act name and date and so forth. You could refer to things, and you could refer to pinpoint subsections of other statutes, like and say this applies as the term is defined in this other statute, and give a pin site to it. And now that saved a lot of time for legislators. I mean, it saved a lot of time for courts, right? But I want you to see that if you can do that, that's a really neat trick. It's like, I could almost analogize it to being able to compress files or something on your computer. So you can, so what this means is now that judges, part of the interpretive task is flipping around where these cross references, where one statute refers you to another, which refers you to a third, and so forth. So it saves time for the legislature, but it can actually mean that now a court has 3 statutes to bring that bear on the case that they have to decide how they tie together and what they mean. Codification made it super easy for Congress to amend and expand prior enactments, right? So there's sort of a path dependence here. You have to, as if you're in Congress, there's a lot of political capital that you have to trade votes to get votes for your statute that you're sponsoring. So if you want to regulate something like, let's say new, like cryptocurrency, or vaping or something like that, that hasn't really been regulated before, and we're going to have a brand new statute, that takes a lot of political capital to get people lined up to vote for it and pass it. But once it's on the books, it's not that big a deal to add a clause or add an exception or add a rider to another bill that says, oh yeah, and the Clean Water Act also applies to this. Or when you're enacting future statutes about other things, to incorporate, again, to basically say the Clean Water Act controls here too. Well, you've just expanded by one line the scope of the Clean Water Act if you do that. And so this codification in this sense made it really feeds and fuels the proliferation of statutes. Also, if you're in the legislature, you can detect gaps in the law that you want to fill. And once it's codified and arranged topically, you can sit down and see, well, what do we have about child custody disputes across state lines or something like that, and or about wills and estate taxes, and read all of the statutes on the topic at your fingertips, and then figure out, you know, we've never really addressed this important question. Let's fill in the gap here. And so all of this means that codification made the process of legislating much more efficient. And by lowering the transaction costs, legislating became more prolific and productive. Okay, next we come to the Great Depression in the 1930s and the New Deal. So there was tremendous across the board political pressure for the federal government to solve the crushing economic crisis, and which was also happening at the same time as a healthcare crisis and an elder care crisis, and the need to expand the infrastructure. People had all of a sudden had cars that could drive, that were much more reliable than the early Model A's and Model T's, but they didn't have enough roads to drive them on. And people wanted electricity. Remember, that was pretty new in the Depression era. So they wanted hydropower plants and power and electric companies and so forth. So this meant a lot of pressure for the federal government to solve all of our problems. And it was very politically popular. And I understand we have a big movement, counterweight movement of the libertarians and conservatives now, who think that we don't want the government to intervene in our lives so much and regulate everything. But in the 1930s, people were fed up and wanted the government to do more and to solve more of their problems. And so this was very popular. And the New Deal simultaneously brought in a lot of our modern administrative agencies that didn't really exist before. And they started promulgating regulations that look like statutes. They are also codified in the Code of Federal Regulations, the CFR, with titles and enumerated sections and lettered subsections and so forth. And so now we have this question of, not only do we have these things that look and have the legal effect of statutes, so to that extent interpreting, they present a whole new exponential increase in the stuff courts have to interpret, these statute-like texts for them to interpret. But we also have a whole body of case law, the Chevron deference and Auer deference and Skidmore deference, about the complicated relationship between these regulations and the statutes that courts in the common law era didn't have. Okay, so courts in the 1900s or early 20th century simply encountered a lot more statutes and regulations than judges had in previous centuries. And they had to develop interpretive tools and methods to cope with this. So are things like the use of legislative history, which becomes popular for the first time in the 20th century. The canons of construction, which suddenly became much more important, right? The use of dictionaries, and also constitutional questions about the validity of the statutes, and then things like the non-delegation doctrine and federalism and concerns like that all really rise up once we have so many statutes to interpret. Okay, that concludes our quick what happened and how did we get here with so many statutes that courts have to interpret.